going to wait a couple minutes to let everybody filter in, and then we'll get started. Okay, so it looks like people have started to filter in. So I'll get started on some quick housekeeping, sorry. So welcome everybody to our criminal justice program briefing. I want everybody to know this is being recorded. We will make a copy available to you after the webinar is over. If you want to view it again or send it around, your cameras aren't on and will remain off the entire webinar, but you can ask questions at the end of the webinar. There's a Q&A section. If you could put your questions in there, we'll try and get to as many as possible. Um, and with that, I'd like to begin this by doing a land acknowledgement. So I'd like to begin by recognizing that our speakers today are joining from different locations across Ontario, and we know that many of you are joining us from communities across Canada. Because of this, we cannot acknowledge all the Indigenous lands represented here today, but we encourage everyone to learn about the traditional territory you are on and the nations who have cared for that since time immemorial. That being said, I would like to acknowledge that CCLA's office is in Toronto, which is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis people. In the spirit of reconciliation, we acknowledge the land that Indigenous peoples have lived on and cared for since time immemorial. We are honored to be able to live and work on this land. And with that, I'm going to pass it over to CCLA's Executive Director, Howard Sapers. So, Howard, over to you.
Thanks very much, Michael, and welcome to everyone. Thank you very much for joining us. If we were in an auditorium, it would be a packed house, and that's great to see. My task today is really simple, is to introduce Shakir Rahim, who is the director of the Criminal Justice Program for the Canadian Civil Liberties Association. I think many of the people who have signed in to this webinar know you, Shakir, but I will read a brief snippet of your bio for the few that don't know you well yet. Shakir is a lawyer. The program that he manages for the association has for its objectives protecting and developing charter rights in criminal law. It focuses on police accountability and prisoners' rights as well. Shakir manages the criminal justice component to the CCLA's Supreme Court intervention practice. He designs and oversees strategic litigation, testifies before Parliament on law reform, appears in media on topical criminal justice issues. Prior to joining the CCLA, Shakir practiced criminal law and human rights law, and he was involved in public interest advocacy throughout his career on a range of issues. It's a pleasure to have him on board with the CCLA, and I'm really excited to hear what he's going to be sharing with us this afternoon. So, Shakir, over to you.
Well, thank you kindly, Howard, for that introduction. And I echo Howard's note welcoming everybody here today. It's really inspiring, actually, when we see so many people who care about criminal justice issues and our charter. And it's our pleasure to be able to talk about some of the work that we have been doing. So in my presentation to you today, I'm going to focus on three main areas. I'm going to talk a little bit about the landscape around criminal justice issues in Canada today, focusing on two or three themes that we have noticed at the CCLA and acted upon that cause us concern. I'm going to talk a little bit about some of our major litigation this year in the program, and in particular, some of the Supreme Court decisions that have come out where we have acted as an intervener. And then finally, I'm going to talk a little bit about some current advocacy around federal legislation, in particular, Bill C-14, which, as many of you may be aware, is targeted at a number of different provisions in the criminal code, but particularly around changes to the law of bail. So, with that, I will begin, as I mentioned, with a discussion of some of the themes that we've been observing in the program. And the first one is something that I think we notice across program areas, which are uh, threats that are emerging to important norms in our constitutional democracy. And for the criminal justice program, we have been particularly attuned to different types of threats to prosecutorial independence and judicial independence. So what do these mean for those who may not encounter these terms on a regular basis in their line of work? Well, prosecutorial independence is really a cornerstone of the criminal justice system. And what it means is that a Crown prosecutor makes decisions about the conduct of a prosecution, whether to continue a prosecution, how to approach it in terms of recommendations around sentencing or charges fully independently. So, it's their job essentially to ignore fear or favor, no matter what a politician might think, uh, what certain parts of the public might think. A prosecutor has a fidelity to the rule of law and also to ensuring that they act in the public interest, which is defined by different prosecutorial manuals across the country. And you might see if you follow some of the news down south, what happens when this really important norm is eroded. You have situations where the head of a government will direct the prosecution to pursue criminal charges against specific people, for example, for reasons that might not be related to actual criminal wrongdoing. And what we've seen recently in Canada is certain specific kinds of threats emerge to prosecutorial independence. And there is one incident in particular where we did speak out and are continuing to follow that illustrates this. And that was a major and unusual press conference given by the Edmonton Police Service in September of this year, where they specifically called on the Crown not to pursue a certain sentencing agreement in relation to a criminal matter, because in their view, it wasn't a serious enough sentence that may have been imposed. And the police service also said that if the Crown did not resile from its position, that they would selectively make information about the case public, essentially waging a kind of public campaign to bully the Crown into adopting their preferred approach in the case. So this was concerning, one, for the reasons I just alluded to about why prosecutorial independence is important to ensure that we are all treated fairly under the law and not subject to politicized prosecutions or those that are based on interests that extend beyond the law. But also because, the police are performing a very different function than the prosecution or the defense or the judiciary, for that matter, in our system. Uh, they are not lawyers. They are not aware of all of the different issues that might be at play in a case in terms of its strengths and its weaknesses. Um, the standard to lay a criminal charge is different, of course, than the standard for a conviction. It's also different than the standard that a prosecutor might apply to decide whether or not or how to proceed with the prosecution. So the police are the first stage of a process, but a lot of other considerations enter the picture afterward. And in this particular example, for instance, there was a lot of inaccurate information that the police provided about that specific case and what the prosecution's intent was. And so we issued a strong statement along with many other organizations around that. And, just recently we've actually heard that there have been some unusual changes to some of the top prosecutors in the city of Edmonton. And we're certainly following that to see what may or may not have been the motive behind some of those changes. So, in addition to that, we have seen attacks on judicial independence. And this, I think, is even more pervasive than our observations around prosecutorial independence. So we've heard premiers, for example, say that judges are unelected, so they lack legitimacy to issue rulings on certain issues, including many that directly implicate charter rights. We've seen attacks on judges and their decisions, often in a manner that demonstrates that a politician has not actually read the ruling or understood why it was made. And we have also spoken up about that. So, for example, in April, the Premier of Ontario made some comments about how judges were unelected and didn't have the legitimacy to make certain kinds of decisions. And we and other organizations issued statements and public comments on that. And that evening, actually, Ontario's three chief justices of the different levels of court came together to issue a statement defending judicial independence. So we continue to be concerned about these kinds of erosions of core principles in our system. And we're concerned not only because, any single instance of this is a problem, but it's really important to be eternally vigilant about these principles. As soon as you let one case or one example become the one where we accept an erosion of this independence, the easier it gets for the next case and the next one and the one after that. Until at some point you realize, oh, it wasn't just about that one example, but we've lost a protection that we all should enjoy. So the second thematic issue that I think we've noticed, and this is not a new one, unfortunately, but certainly one that we are continuing to see more and more of, is the absence of evidence-based criminal justice legislation and policy. And so what do we mean when we say that, the absence of evidence-based legislation policy? Well, what we see more and more of, and I'll talk about it specifically to around the Bill C-14 and bail legislation, is politicians talking about or proposing legislation that's sort of based on, they might say, well, the perceptions that Canadians hold or concerns that exist around something, or responding to calls for X or Y issue. But there isn't a lot of data or qualitative and even quantitative evidence behind those proposals. So, instead of saying, okay, we've done an analysis of this many number of cases, and this is the issue that's arisen, and that's why we need to change this particular part of the criminal code, we don't actually receive that kind of information when these items are proposed. And so, in bail, for example, no jurisdiction tracks the number of people who allegedly reoffend on bail. It's a point that we've made many times, all the way up to the Prime Minister's office. And yet, we have some major changes coming down the line where there isn't really a foundation of data available to understand how that's going to have a broader impact on the system and the perceived concerns that exist. So we continue to emphasize and encourage policymakers to strengthen both the use of data and evidence in their decision making and the collection of that data and evidence. And of course, that's not just us, it's many of our peer organizations as well that are calling for that to be a more significant part of our law and policy making. So with that, I'll move on to discussing some of our litigation highlights of the year. And I'll begin with a Supreme Court case called RVIM. And this decision was released in July. And it concerned the interpretation of an important part of the Youth Criminal Justice Act. So, the Youth Criminal Justice Act is a special kind of legislation that governs the uh, charging and prosecution of young offenders, people who are under the age of 18. And it's a special legislation. Like, there's a reason why it exists separate than the adult system and the adult legislation that exists, because it recognizes that young people who allegedly commit offenses are, by virtue of their youth, in a really different kind of situation than an adult. Um, there is more of a prospect for them to be rehabilitated. They often may be experiencing very unique kinds of vulnerabilities that adults might not. They could be uniquely at a power disadvantage in an interaction with a police officer, for example. And so there's all kinds of different protections for that reason in the YCJA that exist. And one of those protections is that there's an emphasis on sentencing young people who are convicted of a crime in a way that emphasizes the prospect of rehabilitation and recognizes that their sort of development and maturity is different than an adult offender who's similarly situated. And so this case was about that last element of the YCJA that I mentioned, because there is a provision that allows a young person to be sentenced as an adult, so to receive an adult sentence. And the issue in this case was, what is the standard? How do we interpret the standard to make that jump? And we submitted two things. One, that the standard is a high standard, that it's important that there is an adequate evidentiary foundation before the court beyond a reasonable doubt. The standard is the standard that we proposed, and that was the standard the court upheld in its decision. And also that the inquiry really has to be about the young person's developmental age and capacity for moral judgment. So it's not about how significant or serious the offense was in isolation. It's really about, if we look at this young person and we evaluate their level of maturity, their capacity for moral judgment, are those like an adult's? And that would justify departing from the YCJA, because in those limited circumstances, some of the principled reasons why they should be treated differently as a young person may not be present. And so the court's decision reflected that position that we conveyed as an intervener. And they also cited our submissions in their judgment when making some of these points. The second decision I'd like to briefly mention is the court's ruling in R.V. Wilson, also a Supreme Court of Canada case, which was delivered in October. The judgment was delivered in October. And this is a case that concerned the statutory interpretation of part of the Controlled Drugs and Substances Act. And essentially, Parliament made an amendment to this act, which basically said that, if somebody is seeking emergency medical care for themselves or another person, they cannot be liable for the criminal offense of simple possession of a substance. And so you can think about, in the context of the fentanyl crisis and other types of substance use crises that we have in Canada, why this is important and why Parliament thought it was important. Because in their view, if you need to have your life saved, you shouldn't also be thinking about, could I get arrested for having used this substance? And in this case, the question was, well, even if you're immune from prosecution or conviction of this offense, does it mean that the police are not permitted to arrest you for it? So a case arose where the police arrested somebody for simple possession, um, but of course they could not actually have that as a charge that would go through the system or have a conviction entered for it. And our view was that it would really defeat the purpose of the provision if you could still have someone fear an arrest for possession of a substance, because that would still create the kind of deterrent effect for them to receive or seek emergency medical care. And we emphasize as well that a lot of people who may be dealing with substance or addiction issues, might have a very difficult relationship with the police, where even going through the process of an arrest could be really destabilizing for them, or otherwise impact their well-being and welfare. And so the court issued its decision where they said, look, interpreting this provision, thinking about the purpose behind this law, makes it clear that the police cannot arrest somebody for an offense where they're immune from prosecution or conviction. And again, they cited our submissions, particularly around understanding interactions between vulnerable populations and the police. And it's an important decision from a broader perspective, from a pure civil liberties sort of perspective, because it'd be very peculiar for the police to have a power to arrest you, which is a significant intrusion on your liberty for offenses where you will never face a criminal prosecution. What else could the power of arrest be for but that? And the police still retain all kinds of other powers, if there's exigent circumstances, if there's a safety issue. So it's not as if their hands are tied behind their backs when they encounter different situations. But in this specific respect, when Parliament says you cannot be prosecuted or convicted of an offense, the police can't turn around and say we're still going to arrest you for it. So finally, the last decision that I'll touch on is one where we've had our appearance, but we are still waiting on the judgment. The appearance was quite recent. And this case is called Edmonton Police Service v. McKee, and we appeared in September in regard to this case. And it concerned the interpretation of a really important charter right in the criminal process, the right to full answer in defense. And how our courts have interpreted that is to mean that, the Crown, the prosecution, has to hand over to the defense any information that has potential relevance for the prosecution. And you can see why that's important, because if the defense didn't know about something, let's say a real problem with the Crown witness or expert evidence that contradicted what the state was arguing, then we could really see innocent people being convicted, and they have been convicted, and we've had wrongful convictions because of inadequate disclosure. And the Supreme Court has specifically addressed the question of, well, what about information about police misconduct? That's what this case was about, the scope of police misconduct information that has to be disclosed. And in a decision called McNeil, the court talked about what kind of information would have to be disclosed, and provided a framework for everyone to understand how to approach that. And in this particular case, the Crown happened to know about a disciplinary matter that a police officer who was involved in the investigation was involved with. They knew about it because of a different case, so it wasn't relayed to them as part of this case, but they provided that information to the defense. And it was actually the police that objected to that. So the Crown and defense were on the same page here about that information needing to be provided to the accused person. But the police claim that, where something isn't directly about that specific case, so the Crown knows about misconduct through some other avenue, whether it's because of a different case that it came up, or maybe they just have the report lying around somewhere, that information should not be automatically disclosed. And similarly, um, they made the point that if the disciplinary information uh, has been, there's a process provincially where that information, they called it expungement, but that's not the correct term. It's sort of been wiped away, let's say, from the disciplinary history. So when you're thinking about does the officer get promoted or what have you, that doesn't form part of their file anymore. The police admitted that that should basically extinguish um, any automatic disclosure of that information. So if the act says in 5 years, this isn't on your record as a police officer, the position of the police service was that, well, the Crown can't disclose that automatically. As you can imagine, we argued that there really should be a robust and extensive disclosure of that kind of information, that it doesn't matter how the Crown came into possession of it. What matters is it relevant to the specific case at hand? And it was a very interesting case because the court was quite clearly concerned with the position that was being put forward by the Edmonton Police Service. And of course, the Crown and the defense were aligned that this was the right decision to have made to disclose the information. So we'll look forward to receiving that decision probably sometime next year. So with that, I'll talk a little bit about some of our current legislation and advocacy. And probably one that you've seen in the headlines is bail reform. And the federal government has proposed new legislation that's going to do a whole host of things to the criminal code, but really significantly alter some provisions around bail and also sentencing. And as you know, the CCLA has a long interest in this subject matter. We've published two major reports about the bail system, one in 2024 and one in 2014. And we've been quite active in the public sphere in discussing bail, its status as a charter right, and understanding bail in the context of broader concerns around public safety. So there's a few sort of concerns that we have with the legislation and the conversation around bail. And we testified actually before the House Standing Committee on Justice in October. That's on our website and our YouTube channel. So if you want a bit of a broader overview of some of these issues, I encourage you to view that. So one of our concerns has been that there has been in talking about public safety, what makes the public safe, what affects crime rates, a really narrow focus on bail alone. And we know that true public safety requires a whole host of different things, right? It requires investment in crime prevention. It requires correctional facilities that can rehabilitate people. But we've seen now that the conversation on public safety has really been focused on this idea that bail is somehow the most significant factor in understanding public safety. And I just want to quote to you a recent decision from the Ontario Court of Justice in a case called Garlow, which I think speaks to, why this focus on bail alone misses a lot of the picture of what's going on. So here's a quote from that judgment. Despite a multitude of decisions from every level of court in Ontario decrying the abuse of vulnerable inmates, absolutely nothing has been done to alleviate this unjustifiable treatment of people at the mercy of the state. It is mind-boggling that a country that prides itself on its purported respect for human rights is turning a blind eye to these documented, undeniable, and inexcusable cruelties. Instead of addressing these concerns, politicians demand more pretrial incarceration without taking any steps to ameliorate the overcrowding, understaffing, and inability to house the current population, let alone incarcerate more people. It bears repeating that these are people, human beings, not livestock. Those are some fairly powerful words from a justice, and they really reflect the fact that the conditions in remand centers, so in places where people are placed if they're denied bail, are really in a state of crisis. There are hundreds of decisions in Ontario alone about the poor state of our facilities. And we know, of course, that these concerns about prison conditions also extend federally as well. So, for example, the Office of the Correctional Investigator recently issued its annual report that really decried the uh, treatment and services available for those with mental health challenges in federal prisons, and noted that many recommendations that have been made for years have simply gone unaddressed by the relevant bodies at the federal level. So that's one of our concerns, is that there is this very narrow focus, and of course an ignorance of other parts of the bail system that are equally important, such as the conditions in pretrial detention. The other major element that we've highlighted is the absence of good data. I mentioned earlier in the briefing that no jurisdiction collects information about rates of reoffending. And so, we do hear very concerning stories, I think, in the headlines about maybe somebody was on bail and allegedly reoffended, but we miss a lot of the ability to actually look at that in context. How many people on bail for that offense allegedly reoffend? What were they on bail for, and what was the conditions that they had, right? Was it a bail for a simple offense where bail is routinely issued, or was it for a very serious offense where it was unusual to receive bail? Um, so we don't actually have this information. We have really advocated strongly that the federal government, in collaboration with the provinces, has to do a better job of collecting it. And we made that point quite directly to the Minister of Justice in our meetings with him. We've made it the same point with other policymakers and government officials. We've tried to provide the government with information about how to coordinate among its own agencies to start collecting that information. But it really is a gaping flaw in our system, and one that makes it difficult to not only inform what we should do, but evaluate what it does. So, bail reform, another bill was passed a few years back, Bill C-48. There's actually no way to say, well, here's the, impact on those particular offenses and the the rate of reoffending. And of course, what we do know, and the information we do have, is that the number of people in pretrial detention has gone up in Canada quite a bit, not down. So in 1978, around 22% of people in provincial prisons were people who were um, in remand, in pretrial detention. And now that percentage is about 76%. So, over a tripling uh, of that number. And so that really kind of creates some tension with some of the narrative that we hear, that bail is just so easy to obtain, that everybody's getting it. The reality is that the numbers and what we hear about the conditions in prisons, and the overcrowding tell a very different story. And Bill C-14 has a particular element that's become a very frequent now part of legislative proposals from the government, called reverse onus provisions on bail. So what is that? What is a reverse onus provision? So as you know, under Section 11E of the Charter, we all have a right not to be denied reasonable bail without just cause. You'll note that's not an automatic right to bail. It's not a guarantee of bail. It's that if you are going to be denied bail, there has to be just cause for doing so. And so the way that's been interpreted is that it's the state that has to prove why you should be denied your liberty pending trial, right? Because you're facing an accusation that hasn't been tested in court. And so if your liberty is to be deprived, it's the state that's going to have to prove it. A reverse onus flips that on its head. Now it's you who has to carry the burden of saying why you should be released before you've been convicted of anything. And the Supreme Court, in two decisions, Pearson and Morales in the early 1990s, said on its face, that is a violation, every reverse onus of Section 11E. But it's a violation that can be justified in very narrow and exceptional circumstances. If there's a really specific reason to the operation of the bail system that a reverse onus is necessary. But, in our view, we haven't seen the thinking, the rationale from the government as to why these particular offenses that they've chosen have an issue in terms of how bail decisions are made that justifies a reverse onus provision. And all the new reverse onus provisions apply to first-time offenders. So the government has said, well, this is about, people who are repeat violent offenders cycling through. But it applies equally to an 18-year-old who's never been in trouble with the law. They are now going to face a reverse onus if they are charged with certain offenses like break and enter, motor vehicle theft. So that's a concern. And another big concern about this bill is that it limits judicial discretion in sentencing. So, as you know, CCLA has always maintained that proportionality is critically important in sentencing. A judge looks at the person before them, they examine the circumstances of the offense, uh, and they weigh what that person's responsibility was, their history, uh, all kinds of different considerations and principles to finally arrive at a fit and proportionate sentence. And one part of proportionality is judges in Canada have the ability to impose a consecutive or a concurrent sentence. So what does that mean? You might have seen maybe headlines, sometimes they come out from down south where someone's sentenced to like 400 years in jail, right? Or 300 or 200 years in jail. And how does that happen? Well, what happens is that the sentences are stacked together. So, there might be a single event that leads to different criminal charges. And when you're convicted, all those sentences are stacked together. Our approach is different than that. Judges do have the ability to impose consecutive sentences, but they can also impose concurrent sentences where they say, look, we look at the incident overall, we look at the offenses in question, the moral blameworthiness, all these things, and here's the right overall number for what happened. And so they can say certain sentences are served concurrently at the same time. And it's really important because there are cases, many cases, where you might say, again, like it's a first-time offender, or maybe there are other circumstances, their responsibility, maybe they just, bought something that somebody else used, still in a criminal matter with culpability, but they weren't at the scene, all these kinds of things. And this removes some of that discretion. So for certain combinations of offenses, the bill says you cannot impose a concurrent sentence at all. It has to be consecutive, stacked. And so we're concerned about how that's going to affect the proportionality of the sentences that are imposed. So that's it for the portion of me talking to you of this briefing. And I know we're going to have some time for Q&A. So I'll hand things over now to Rosemary.
Okay, thank you very much, Shakir, for that wide-ranging and very interesting update on CCLA's criminal justice program. We have quite a few questions that have been coming in, and I just want to remind everyone who's on the webinar today that there should be a Q&A button down along the bottom of your screen in Zoom, and that's where you can type in your question. And we've already got quite a few, so we'll get started right away. The first one is, what civil liberties arguments are available to challenge a lifetime ban that continues to restrict employment and travel years after a sentence is finished?
Yeah, could you repeat that one more time, Rosemary? I just want to make sure I got the question right.
Yeah, this is from one of our participants. What civil liberties arguments are available to challenge a lifetime ban that continues to restrict employment and travel years after a sentence is finished?
Well, I think that would depend on the nature of the ban in question. So I think there's a few different ways that an issue like that could arise. So, for example, one could be that simply having a criminal record affects your ability to travel or seek employment. And CCLA for a long time has been part of a coalition called the Fresh Start Coalition, which has been arguing for what are called automated record suspensions or pardons. So the idea is that after a certain period of quote unquote good behavior, you don't have to apply for a pardon or a record suspension. You receive one and you're able to get on with your life. There's, of course, other kinds of factors that could affect that too, right? Being on like a firearm prohibition registry, being on a sex offender registry. There's all kinds of different other types of prohibitions and so forth that could be imposed. And whether or not that's constitutional is something that we address on a case by case basis of the nature of the issue, but it's really again about compliance with the charter, right? So if something is going to deprive a person of their liberty interest under Section 7 of the charter, it has to do so in line with the principles of fundamental justice, and there are various ones that are in existence, and so it would be measuring the nature of whatever the imposition is and the impact it has on a person with those charter rights that people hold as well.
Thank you, Shakir. The next question we have from a participant is about Alberta and the new drug intoxication center, where you are forced involuntarily to be held for 72 hours. Can you comment on these involuntary holds?
Certainly. So, my colleague Harney in our quality program is taking a real lead on this issue. So first, I would commend to you our public statements on it. But certainly, I can say that it does raise concerns for us, and from a number of different perspectives. Of course, we're concerned both with the well-being of people who are experiencing addiction issues and the well-being of the general public. But we are very concerned where someone is deprived of their liberty in a manner that may not actually achieve the public health objective that's being discussed. And there's a lot of research and literature about the challenges that are associated with forced treatment types of programs. And as well, our strong view is that it's terribly important that we don't simply criminalize addiction, if you will, right? And so whenever this kind of legislation is proposed, we're concerned about how a health issue is being managed and responded to by instruments of the criminal justice system. And that's something we've spoken about as well. But for specifically on that legislation, I would commend to you our public statements on it from our quality program.
Thank you, Shakir. Our third one is, can you please give an update on the Solomon Fakiri case?
Certainly, and thank you for asking about that. So for folks who may not be familiar, Solomon Fakiri was an individual who was killed in provincial custody. They had some very serious mental health conditions that were not properly responded to. And there was a coroner's inquest after their killing, which established that it was a homicide and gave a number of different recommendations for change. And CCLA has worked with Yusuf Fakiri, Solomon's brother, who's been a very strong advocate, to bring attention to the fact that many of these recommendations have not been implemented. In fact, we don't actually know what has been even considered and why. And so we had a major press conference at Queen's Park earlier this year with Yusuf to call for action on these recommendations. And we wrote a letter to the Solicitor General requesting an update. But thus far, we've received little to no uptake from the government in even acknowledging our concerns. So from our end, we've also started to look into different types of mechanisms where we can receive that information, for example, because of a freedom of information request, so that we can actually just know what the government is saying internally about what they're going to do. But frankly, it would seem the government is fine with ignoring these recommendations and ignoring even, grieving family members who are trying to make change in the system due to the loss of their loved ones. So it's something we'll continue to speak out about. And I know that the Fakiri family and CCLA will be engaging again early in the new year to see what additional advocacy opportunities might be available.
Thank you, Shakir. The next question is CCLA anticipating a challenge over the recent announcement by the Ford government to publish names of those on the sexual offenders registry?
Well, thank you for that question. And it is, of course, an issue that we are following closely. We have not made any decisions yet about what we may or may not do in response. So, what's being proposed by the government is a series of consultations around certain legislative changes. So, our next step is going to be taking a look at what they're proposing to change and how they are proposing to receive information about those changes. So, I have no doubt that we will have a position on that. And whatever is ultimately implemented, once we have that on paper, that's when we'd make a decision about any sort of challenge. But certainly, one of our concerns is it's important that we keep the public safe, and that's why the registry exists. But also that we discourage vigilantism or people taking the law into their own hands. And so, it's a balance that is struck. And if changes are going to be made, they need to be made for the right reasons and have the right effect. And I think from some of the rhetoric that is coming out around it, we're concerned about whether that's actually the case.
Okay, thank you. Uh, you talked about evidence-based facts and data. And in order to have evidence-based data to feed into the bail reform discussion, what kind of data should be collected and who should be collecting it?
Well, thank you for that question. So, first off, who should be collecting it? The provinces are responsible for the administration of justice, so they're the first kind of level of government that would actually be in a position to have a system that gets the right information. But at the same time, for many of the national data sets that we have around criminal justice, it's a cooperative effort. So Statistics Canada, for instance, collects different types of information from corrections, from police services, and collates that and brings that together. So both levels of government have a responsibility to collect that type of information. Now, as to what we'd be collecting, there's sort of a scale, if you will, right? So at the bare minimum, we want to know how many people who are out on bail are allegedly reoffending. What are the alleged reoffenses? That's like the bottom line. But then we also, can benefit from information that's, more granular. What are the specific charges? Is it a minor condition of a bail release plan? Is it like a new substantive offense? A breach of a bail order can fall on a really big spectrum, and so we want to understand when we talk about someone violating their bail, what is it that we're talking about? Then, of course, we also know that a lot of the outcomes in the bail system can be affected by uh, a person being indigenous or racialized or black or vulnerable in some particular way. So having more information about outcomes and the different outcomes among different groups helps us to understand how the system is operating and also understand uh, conscious or unconscious bias and discrimination that can exist. So that's how I would sort of answer the question. Now we have submitted more detailed briefs about all the different data points we think are useful, but as a starting point, I think those are examples of the kind of basic data that we need to be collecting and compiling.
Thank you, Shakir. This next one's a bit long, so just give me a moment to read it. This was in the news recently. There's a police constable who exposed troubling internal group chat behavior, and they were terminated while the conduct she revealed also raised public confidence issues. Does CCLA see this as part of a broader pattern in policing that affects civil liberties and public accountability? And is the organization considering any action or review related to this case?
So I'm not familiar with this specific case that you mentioned, but I certainly can comment more generally on that issue. Um, Certainly, we have seen, and a report actually recently just came out relating to the Toronto Police on similar subject matter, that there have been concerns in terms of officers, feeling harassed or discriminated against, or raising concerns and feeling that there's pushback. So certainly, to the degree that we see certain types of behaviors, organizational behaviors being tolerated that are discriminatory or harassing, that is a concern because it speaks to issues that are then going to arise in interactions with the public. Um, and of course, at the same time, it's important that as an institution, police services meaningfully respond to these types of issues because of the impact it has on the delivery of police services. So the answer to your question is absolutely, it can matter. Yeah, I'd welcome you to contact our public inquiries address, which is on our website, if you want to share information about that specific case that you're referencing.
Okay, thank you. And we also had a question about the Maplehurst Correctional Center and the events that happened there that have come to light over the last year or so. Is CCLA involved at all in what's going on with Maplehurst?
Yeah, so for those of you who may not know, this is an incident that occurred where there was basically an abusive strip search operation at the Maplehurst complex. And so there had been an incident of violence between one guard and one inmate. And in response, they strip searched every single person in the prison, people who had nothing to do with that incident. They lowered the temperatures in the prison to a very cold level so that people would be uncomfortable. Physically roughly handled people. And the superintendent or the individual leading it, whose last name happened to be Wong, referred to the operation as Guantanamo Bay, after the Guantanamo Bay, where obviously there's a lot of abusive things that occurred under U.S. military auspices. So it's a very disturbing treatment of people. And a recent court decision actually found that a lot of the people who were called to testify about it lied in court about what happened. So we have issued a statement on it, especially when the video was released, where we called for different types of actions that should be taken in response, including specific systemic reforms. We are presently on the tail end of a petition that we are preparing that's been signed by members of the public to deliver to the Solicitor General, which is going to call for additional action. And we're also in contact with a lot of the different lawyers and organizations that have been active in relation to it. The Ombudsman, as you know, Ombudsperson of Ontario has also opened an investigation. So I think we're going to continue with the public pressure side of things. But over the horizon, we certainly do have on our minds, the need for litigation or other types of interventions to address conditions in prisons. As you know, CCLA litigated solitary confinement a few years back, and I think it's clear that we have a crisis in all levels of corrections, but particularly as well in pretrial conditions, and we'll be taking a closer look next year as to how we act on that.
Okay, thank you, Shakir. I think we'll make this the last question. And we apologize to people that we couldn't get to your questions. We had way more than we could answer during this time, but we really appreciate that you had those questions. And if you have something about a specific case, as Shakir said, you can go to our public inquiries section on our website and send us a message. So this is one, when people I know talk about a criminal justice issue, and sometimes I feel that their views are not fully informed by the facts or by other perspectives, how would you suggest that I find useful information to give to them?
Well, I think there's a few different routes that you can take. So the first thing that I would say is that if you ever have somebody who's talking about a court decision, is to actually go and read the decision. Because often what the media might report, or especially what might be on social media about what a decision said, may not actually reflect its content. So that's the first place I would go for anything that's related to a court making a decision. Reading it will often give you a much more grounded perspective on what the court said and did not say. Another source that I would really suggest is, on different types of legislation, like Bill C-14, or issues like bail, there's a lot of parliamentary committees that do studies. And those proceedings are available online. You can see like who all the different witnesses were that appeared. You can watch them. You can read their briefs. So that's another really useful place to look if you're asking, well, how can I find information from different perspectives on this issue? Is you can go to the website for the Justice Committee of the House of Commons, and you can find what the study has spoken about in relation to any particular bill or legislation. And then finally, of course, I think it's by following different organizations on social media. So, like the CCLA, but also groups like the John Howard Society of Canada or of Ontario, the Canadian Association of Elizabeth Fry Societies, the Canadian Bar Association. A lot of these groups do post frequently to provide grounded, informed perspectives about our system, and that's another really useful place to turn to.
Okay, thank you very much, Shakir, and thank you very much for the briefing and for answering all the questions. I'm going to turn it back over to Michael Lowry now.
Perfect. Yes, so it's almost 4 o'clock, so we're going to be wrapping up things here now. We do have one final webinar coming up on December 17th, and you'll be able to hear about our education program and the great work that the Canadian Civil Liberties Education Trust is doing. So we'll be sending around invites to that in a few weeks, and we hope you will join us then with that as well. Really, thank you all for coming. A reminder, we will be sending around in an email in about a week's time a link to this webinar if you want to view it again or didn't get a chance to see the whole thing. We'll be sending around a link. So we'll leave it at that. Have a great afternoon, everybody, and we'll hopefully see you at the next webinar in December. Thank you. Bye.